Ceasefire agreements occupy a central place within the architecture of international peace and security. While often perceived as temporary pauses in hostilities, their legal nature, operational structure, and political significance extend far beyond a mere cessation of fire. In modern conflict resolution practice, ceasefire agreements serve as pivotal instruments that stabilize volatile environments, facilitate humanitarian access, and create the procedural and normative foundation for durable peace negotiations. Their importance has intensified as contemporary armed conflicts have grown more protracted, asymmetric, and fragmented, making the legal design and enforceability of ceasefires a subject of increasing scrutiny. Legal nature and classification. Ceasefire agreements emerge from the intersection of treaty law, the law of armed conflict, and the political processes of conflict resolution. Their legal character depends largely on the parties involved, whether states, non-state armed groups, or international organizations, and on the formality with which the agreement is negotiated and adopted. 1. Ceasefire as an international agreement. When concluded between states, ceasefire agreements can assume the form of binding international treaties under the Vienna Convention on the Law of Treaties. In such cases, they create mutual legal obligations requiring cessation of hostile acts, withdrawal of forces, or compliance with monitoring mechanisms. State-to-state ceasefires generally bear clear legal force, particularly when deposited with the United Nations or integrated into Security Council resolutions. 2. Agreements between states and non-state armed groups. A large portion of contemporary conflicts involves non-state armed groups whose legal capacity to conclude treaties remains contested. Although not typically considered subjects of international law in the classical sense, they possess functional legal personality within the framework of international humanitarian law, IHL. Ceasefire agreements involving non-state groups therefore acquire a hybrid legal nature. They may bind the parties politically and morally, and they may create obligations under IHL, particularly Common Article 3 of the Geneva Conventions. But they do not always constitute treaties in the conventional sense. 3. UN-sponsored or UN-mandated ceasefires. Some ceasefire arrangements arise through United Nations Security Council resolutions. These can impose obligations on all parties to a conflict pursuant to Chapter 7 powers. In such cases, the ceasefire owes its legal force to the binding authority of the Council rather than to the consent of the conflict parties. Modern practice also includes UN-brokered ceasefires, where the UN acts as mediator or guarantor, but not as a party. 2. Core elements and structure of ceasefire agreements. While ceasefires vary widely according to conflict context, successful agreements tend to share common structural features designed to ensure clarity, predictability, and enforceability. 1. Scope of the ceasefire. A legally sound ceasefire agreement defines the scope of prohibited actions with precision. This may include termination of offensive operations, suspension of movements by combat units, cessation of artillery, missile, drone, or air strikes, restrictions on recruitment, mobilization, or arming of forces, withdrawal from frontline positions. Specificity is key, as ambiguity often leads to conflicting interpretations and rapid breakdown of the truce. 2. Monitoring and verification mechanisms. Most durable ceasefires rely on international monitoring bodies, such as UN peacekeepers, OSCE missions, or regional organizations, to ensure compliance. The rules and mandate of such bodies must be established in legally precise terms, including access to designated areas, right to investigate alleged violations, reporting procedures, authority to mediate disputes. Monitoring is essential to transforming the ceasefire into a credible and enforceable obligation. 3. Implementation timelines and phased measures. Ceasefires usually incorporate timelines for phased implementation, such as initial cessation of fire followed by disengagement, creation of buffer zones, or humanitarian corridors. Clear sequencing prevents chaotic or ill-coordinated compliance efforts. 4. Humanitarian provisions. Ceasefire agreements often include commitments related to safe passage for humanitarian aid, evacuation of civilians, protection of medical personnel, exchange of prisoners or detainees, restoration of essential services. These provisions derive both from IHL and from the broader humanitarian imperative of stabilizing conflict zones. 5. Dispute resolution and enforcement measures. A robust ceasefire agreement typically includes mechanisms for resolving disputes, joint commissions, liaison officers, or arbitration panels, and may outline consequences for violations. In rare cases, agreements incorporate sanctions or referral to international bodies, although enforcement remains challenging when political will is weak.